what I wanted to talk about today is the Ministry of Labor and their role. And I'm thinking in particular of Ontario, but it's pretty much the same across the country in each jurisdiction. Every province has its own ministry, which deals with its own particular employment standards legislation, because of course in Canada, every jurisdiction has its own legislation. And in one of the issues that was identified in the lead up to Bill 148, one of the concerns was the lack of knowledge and understanding of employment standards legislation. So one thing I will say is employers and employees, everyone should be aware, the Ministry of Labor in Ontario and again across the country, they have great websites. The Ministry of Labor in Ontario particularly has an excellent website. It has guides, it has tools to help you understand the exceptions, which types of workers are governed by which regulations, which are not covered by which regulations, who gets overtime, who doesn't, etc. They have calculators, so if you need to understand how to calculate vacation pay, severance pay, etc. There's a lot of great tools on there, and you can also call them, and they will give you helpful information. My criticism, and what I want to talk about today, is the fact that the ministry will not make people aware of the limitations of the information that they are giving. And what do I mean by that? They will advise you with respect to the employment standards legislation. They will not provide you with advice regarding any of the other laws that will govern the employment relationship. And as I'm sure most viewers will know, the employment relationship in Ontario is governed by a multitude of laws: employment standards, occupational health and safety, human rights, privacy, labor law, the common law, contract law, and there's probably a few others I'm forgetting. So the challenge that we have as a ministry is advising you with respect to just one of those. And the best example is usually when it comes to termination of employment. So again, as many viewers will know, termination of employment is governed by employment standards legislation, which sets out the absolute minimum amounts people are entitled to, but it's not the end of the story. And the common law will provide that they may be entitled to substantially more notice or severance than the Employment Standards Act requires. So take the example, and I wrote this down before just to keep it clear in my head. Take an example of a 20-year sales employee who's 63 years old, working for a relatively small employer with a payroll of less than $2.5 million. If the employer had to let this individual go, perhaps because of a downturn in the economy or whatever reason they have, and they were to call the ministry or go on the ministry's website, the answer they would be given is that they have to give this person 8 weeks of notice or termination pay, period. That's it. Whereas the common law would say they are entitled to quote unquote reasonable notice, which takes into account length of service, age, the nature of the job, and anything else that's relevant. And although the common myth out there is 1 month per year, that's not the law. It's often not a bad estimate. So in this context, our 20-year employee is 63 years old. If the employer calls the ministry or goes on their website, they're going to be told to give him 8 weeks. And yet the reality is if they are entitled to common law reasonable notice, it's probably 18 or 20 months. So in this context, the employer may be breaching this individual's rights and giving them far less than they're entitled to without any intention of breaking the law. And if the individual wants to make sure they're getting everything that they're entitled to, and they're going to do the smart thing, they're going to call the ministry, and the ministry is going to tell them the same thing. You're entitled to 8 weeks, period. And they might walk away from 16 or 18 months of severance at a time when, in all likelihood, their career is ending. So this is something I've seen it happen time and time again. I still remember one situation I had years ago where I was advising an older couple who ran a restaurant in Toronto, and essentially it was very typical. The man was the cook, the woman was the one who served and took the payment for the check, and they got busy. They hired a waitress, things were going well, and then things slowed down, and they realized they had to get rid of the waitress and wanted to pay her fairly. So this older gentleman went to the University of Toronto Law Library. He found the Employment Standards Act. He dug it up. He checked what he owed this individual, found it was 2 weeks. It sounded really low to him, so he called the ministry. They said, yeah, 2 weeks. He thought he was going to be nice, and he gave her 4 weeks. And next thing that happened was he got a very aggressive demand letter from her lawyer saying he owed her something more like 6 months. And that's when he contacted me. And I was the one who had to tell him that, yes, you did everything right, other than call a lawyer, which would have been the smartest thing to do. But you did everything right, and nevertheless, you now find yourself facing a lawsuit unless you pay some money to make this go away. So again, I can only encourage people to understand the Ministry of Labor provides information in a very narrow scope. So take advantage of that. Use the calculators, use the tools, call the helpline, but understand it doesn't cover all of your rights. And if you're an employer, you need to understand that just because the Ministry of Labor says you only have to do X doesn't mean that's all you have to do. As an employee, just because the Ministry of Labor says you are only entitled to X doesn't mean that's all you're entitled to. The other examples I'll give very quickly before I wrap up is things like probation period. There's this assumption out there that every employee has a probation period automatically when they start work. That's not the case. So even though the Employment Standards Act says you can be let go without notice in the first 90 days, again, the common law would say you have to get reasonable notice. And yet, if you call the ministry, they will say, no, you don't have to give any notice. Or temporary layoffs. There's this assumption as well that you can lay someone off temporarily if business slows down. It's in the Employment Standards Act as to how you can do it. But the Employment Standards Act doesn't give you the right to do it. That has to be in contract, or it can be implied in certain industries. So construction, we all know that, at certain times of year, people might be laid off. That's an implied term of their contract. But for the vast majority of employees, you can't be temporarily laid off unless that right is written directly into your contract. So again, I would just conclude by saying that it is critical that people understand there is information out there, and it's valuable information whether you go to the website or use the phone, but people need to understand that people need to understand the limits on that information, what it is covering and what it's not. And again, although it sounds self-serving, start with the Ministry of Labor, but contact an employment lawyer to make sure you understand your rights and your obligations before you take any action, or you'll find yourself either subject of a lawsuit or leaving a whole lot of money on the table. So that's my time to fire away from today, my 2 cents worth, and you got it here for free.